Good evening, everyone. I think we can begin with the program. Mayank, can you hear me?
Yes, ma'am.
So I think we can start the event. The speakers, they must have joined, I guess.
Ma'am, Mayank Bhai is just briefing them in the breakout room. He said once it's done, I'll add them to the main session and then we can begin.
Okay, so just let me know when we have to start. Right?
Sure.
Good evening. Elizabeth, can you hear us?
Yes.
Yeah.
Perfectly.
Good evening. Good evening.
Good evening. Good evening, sir. Neeraj, sir.
Good evening,
Hello,
sir.
good evening.
Neeraj sir is also there. Good evening, sir.
Good evening.
So I think Professor Queenie, the senior faculty, she has also joined. Just 1 second. Let me check.
So I'll just quickly like to introduce our faculty coordinators to the speakers, Professor Vandana Singh and Professor Zubair Ahmed Khan. They have been a big support to bring this conference, to materialize this conference that we thought about. And it's a huge, huge thanks to them and their support that we could actually make this happen. And as ma'am just told us that we also have senior professor, Ms. Queenie Pradhan with us.
And we have ma'am, I think Niyati Oja is also with us. Hello, Niyati, how are you? Unmute yourself.
How are you, sir? I'm good.
I'm fine, I'm fine. So it's been a
Nice.
long time.
Yes, Niyati, nice to see you.
Yeah.
Professor Queenie has also joined. Professor Queenie, can you hear us?
Yeah, thank you, Vandana and Zubair. And
Good
hi,
evening.
Niyati. How are you? Good to see you after ages.
Yes, it's been 5 years now. Yes.
Yeah, long time.
So, Mayank, I think we can begin with the program because students are already there. We already decided to have a short group for this value addition course. So, if all the speakers permit, we can begin with the event. Okay, thank you.
Sure, ma'am.
Mayank?
I think we can begin.
Yes, we can.
So-
We should do it.
Thank you, ma'am. Greetings, everyone. I take this opportunity to introduce this conference on resolving disputes in the metaverse. This is an initiative taken up by the ADR Cell, University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University. I welcome you all from around the world and thank you for gracing this event. And I hope that we can create a unique experience with thought-provoking discussions on cutting-edge issues related to ADR and the metaverse. Garrick, next slide, please. I'd just like to give a brief background about our college. University School of Law and Legal Studies was set up in 2001, and it was one of the first and foremost premier law schools in New Delhi, India. Garrick, I'm unable to see the presentation, so could you fix that? Yeah, it's visible now. And being one of the very first premier law schools in New Delhi, it is also it is also in the vicinity of the Supreme Court, the Delhi High Court, and various subordinate courts, which provide the students with the ample amount of opportunities to be able to work with the more industry leaders in the field of law. Next slide, please, Garrick. The Alternative Dispute Resolution Cell was founded in 2020. That is when the world was on its tiptoes during the COVID time. Though it started virtually, we have conducted physical events as well after coming back to college. The cell is headed by Professor Vandana Singh and Dr. Zubair Ahmed Khan. The cell has organized workshops on ADR mechanisms and has conducted events with notable speakers such as Senior Advocate Dushant Dave, Senior Advocate K.K. Sharma, and a long, long list of dignitaries who have graced us with their presence. At ADR Cell USLS, our aim is to be able to create sensitization about these cutting edge issues, such as today's event, which is again our attempt to be able to initiate discussions in about and around topics which are going to affect the future. Without further ado, I would like to invite upon our Honorable Dean, Professor Dr. Amarpal Singh sir, to please present the welcome note.
Um,
Over to you, sir.
Thank you, Mayank. unfortunately, due to bad weather, our Dean sir, he is on the way and he could not join. But on behalf of ADRSL, we are having Professor Queenie with us. She's a senior professor of USLLS. But on behalf of ADRSL, I would like to welcome all the guests, and I would like to, first of all, I would like to thank all the students coordinator, because they have taken initiative and they are having this inquisitiveness that how the dispute resolution nowadays we can resolve in metaverse. So this event, I must say, this is an initiative of ADR cell students, Mayank, Dipanshu, and so many other students who are working day and night, and they are having so many new questions, the contemporary question, that how we can resolve the dispute, what are the procedure, how we are going to enforce any award. So many questions are there for which we need an expert view, and the view of an expert who are dealing in these areas, because in law school we are able to see the substantive law, we are able to read the substantive law, but as far as the procedural things are concerned, for procedural aspect and how these things are happening in real world, we always look towards the professional. So we are so privileged today to have the distinguished speaker with us, the Miss Elizabeth Chan, Niyati, Noor Nicholas, and Sriniraj Ojhaji. Really, we are privileged and we are thankful that all of you have agreed to give your valuable time so that you can interact with our student and you can give us some practical idea that how nowadays we are resolving disputes in metaverse. Without further ado, I don't want our participants to wait further. I just want to request Professor Queenie that if she would like to add something. Professor Queenie, over to you.
Thank you, Dr. Vandana. It is indeed a very important contribution that a value addition course on this particular theme is being organized with such an august gathering and distinguished panelists. I wish all of you all the very best, and I hope these are very helpful to our students. All the very best to all of you.
Thank you, Professor Queenie. Mayank, now without wasting time, we should begin with it.
Thank you, ma'am. Thank you, Professor Queenie, ma'am.
Thank
you. Without further ado, thank you. So without any further ado, I would like to introduce to you all the first speaker on today's panel, Miss Elizabeth Chan. Miss Elizabeth Chan is a senior registered foreign attorney with Allen and Overy in its Asia Pacific team based in Hong Kong. Ms. Chan specializes in international commercial arbitration and investment treaty arbitration and is ranked in future leader in Who's Who Legal. Ms. Elizabeth has previously practiced at leading specialist international practices in London, New York, and Hong Kong. She graduated from Yale Law School as a Fulbright scholar. And she has also hosted many first ever virtual reality arbitration gathering in January 2022, first ever virtual reality arbitration conference in March 2022 as a part of Paris Arbitration Week. We are indeed privileged to be able to host you, ma'am.
Shall I start, Mike, or will you introduce the others as well?
No, ma'am. You can start. You can start on the top.
Wonderful. Well, thank you so much, Mayank, and also thank you very much to the ADRSL for inviting me. It's wonderful to be here, and thanks to everyone who's made this event possible. It was great to hear from Vandana and Queenie as well. So, why are we all here, and how do we get to know this concept of the metaverse? Even though the concept of the metaverse isn't new, it's certainly taken on a new momentum recently, and we're becoming to see the importance of the metaverse in terms of the digital economy more generally, when we have 7 of the 10 largest companies by market capitalization offering some window into the metaverse, or games like Roblox and Minecraft that have billions of people playing it every day and really investing in that community. I have to confess, I'm not myself naturally a tech inclined person. And I actually, my own interest in the metaverse is emerging. So I first became interested in the metaverse when my husband himself had bought a pair of Oculus goggles for his own research, and he's an investor. And once I started playing it, I remember the first time that I picked up a paper airplane with my Oculus glasses on, and I was just amazed by how much it felt like the real world, picking up the paper airplane, flying it. And when I had my first meeting in Horizon Workrooms with my husband, I was just astounded by how much his avatar looked like him and moved like him. And I was really excited by that. And I wanted to experience it with my friends. So as Mayang just described, what I did was I put on those goggles, found other people who were interested in the metaverse, and met in Horizon Workroom. So in Paris Arbitration Week, for example, we had 16 avatars around the table, which felt remarkably like what it would be like to sit in a conference room. And we had another 150 people or so stream in live. And I'm really excited about the possibilities of the metaverse. And one of the really exciting reasons about being here and speaking to students is I think universities are a really great forum for brainstorming these ideas and looking into the future. And I'm not sure how many of you follow this area closely, but a commentator called Matthew Ball recently published a very interesting book on the metaverse, and he talks also a bit about how long the trajectory is, and how we're not all yet off the limit. But there's certainly still going to be a lot of technological challenges around the metaverse. And so my own interest in the metaverse is from a dispute resolution angle, and as yet we haven't actually seen many of any commercial disputes that arise directly out of the metaverse, but what we have seen are a lot of cases relating to the building blocks of the metaverse. So we've seen lots of disputes involving non-fungible tokens, for example, and a lot of cases involving cryptocurrencies. So what I'm hoping to do in my presentation today is draw a little from what we have seen already, and then focus it in particular on some of the enforcement challenges that arise when we try to resolve, or in the future, we try to resolve metaverse-related disputes, either through arbitration or processes resembling arbitration. So I'm thinking about blockchain arbitration. So I think I have about like 15 more minutes. So this is what I'm going to try today. Being the first speaker, I'll just very briefly talk about the metaverse. I'll briefly mention the types of disputes that might arise in the metaverse and the options for resolving it. I won't spend a lot of time on this because I know that Niyati and Nira, I think Nira will be covering these topics. And then I'm going to share with you some research that I'm doing at the moment, writing a paper on just thinking about some of the enforcement issues that might arise under the New York Convention. Which, as many of you know, is a convention that allows international arbitral awards to be enforced in almost every jurisdiction in the world, and which is seen as one of the great strengths of arbitration for resolving international disputes. So to begin with, what is the metaverse? The metaverse is a contested concept, even though, as I mentioned earlier, it's not a novel one. Put very simply, we can understand it as the internet in 3D, and to see it as part of Web3, a new generation of the internet that's based on decentralization, the idea that no one actor owns the internet and can control it. Now, the metaverse isn't a singular concept. It may be more accurate to speak of metaverses, even though that's contested too, or to talk about multiple virtual worlds. Some of these metaverses are centralized with one entity governing the entire network, for example, Meta's metaverse platform, and others are decentralized, which are governed by the users. So some examples would include Decentraland and a sandbox. Some decentralized organizations take the form of decentralized autonomous organizations, or DAOs, where token holders participate in management and decision-making. And so all of these are novel concepts, novel actors, novel ways of organizing collectively are going to have an impact on disputes, and we might need new paradigms for thinking about how we address these challenges. And we've already seen that in court already, courts in the UK, Canada, Singapore, Hong Kong, many jurisdictions have already grappled with the idea of whether cryptocurrency is a form of property. So we're going to see jurisprudence continue to develop in this regard. So as mentioned before, many of the features of the metaverse are based on blockchain technology. For example, NFTs, those come in many forms. It could be the shoes that an avatar wears, artwork in a virtual museum, virtual land, or the cryptocurrencies you use to pay for virtual goods and services. So these are the types of assets that we are already seeing to be subject of disputes, and which may also be the subject of disputes and metaverse related disputes in the future. So what are some of the types of metaverse related disputes that might arise? As mentioned already, we haven't seen any cases, I think, that are that relate directly out of the metaverse. I'm aware of an IP case, but there are already examples of disputes involving digital assets. I'll just give one example, which is Hermes's US lawsuit against an individual artist's creation of NFTs based on Hermes's physical line of handbags. Now, some of the types of disputes we will see will fall into at least two categories. One will be between metaverse platforms and users. So for example, a user might say that there's been some breach of their privacy or their data by the metaverse platform. The second category raises disputes between users. So in the metaverse, users are able to offer goods and services to others, create and sell digital assets to others, rent or resell virtual land. So there's going to be lots of transactions between different users, and as between them, there might be disputes as well. So the next topic is then how will those metaverse related disputes be resolved? And it will be implicit in my presentation today that I think that international arbitration or processes involving arbitration are a good way to resolve international metaverse related disputes. Some of the options for dispute resolution will include litigation, include international arbitration, and blockchain arbitration, and other decentralized justice systems. Now, I think that by default, the courts will be involved in metaverse related disputes, especially where you don't have a choice of forum. And of course, the jurisdiction of an international arbitration is very much premised on parties' consent. So where you don't have that consent, you will need to go to the courts. Now, as for jurisdiction in like some metaverse platforms, have already virtual games, cryptocurrency exchanges, and cryptocurrency wallets already include a choice of litigation or arbitration in their terms of service. But of course, it won't. The issue of which is the relevant forum will not depend just on reading those terms of services. There's going to be national law, mandatory laws, for example, consumer protection laws, which will be relevant to consider as well when we're talking about choice of forum. And I think that, where you do have a jurisdictional choice, there's good reason why international arbitration would be an appropriate way to resolve these disputes. We've seen from the Queen Mary University of London survey, as well as the 2017 Global Technology Dispute Resolution Council Silicon Valley survey, that many tech companies do view international arbitration as a suitable way to resolve their disputes. And some of the most attractive features of international arbitration include enforceability, the ability to avoid a foreign jurisdiction or a foreign court, the ability to choose your decision maker, and confidentiality and privacy. The flexibility of the arbitral procedure also means that procedural rules can be, or the procedure can be molded to suit the needs of the particular dispute. So some of you might be aware of the UK's digital dispute resolution rules, which include key innovations for resolving disputes involving digital assets. And those innovations include having a very short time frame for resolving a dispute. It includes allowing parties to remain anonymous vis-a-vis each other to reflect the fact that often transactions on the blockchain are anonymous or pseudo-anonymous, and empowering the tribunal to directly enforce their award by modifying digital assets directly or transferring them. And an emerging option for the resolution of disputes include processes that resemble arbitration. So like decentralized justice platforms, blockchain arbitration like Kleros, Jour, and Aragon. The idea of a decentralized justice system or the idea of an online dispute resolution system actually isn't new. Like eBay has been using ODR for a long time, but I think decentralized systems aren't really yet part of the mainstream. Certainly, I've been very interested in decentralized justice platforms, but I haven't myself actually participated in a dispute resolution process involving blockchain arbitration. And part of that may be because my own international arbitration sort of focuses on high value disputes where it's very important to the parties to be able to choose their decision maker. But you can imagine that in the metaverse where you have lots of lots of people just making many different types of transactions in the metaverse that may not necessarily be high value. They may be looking for a dispute resolution system that's going to be faster and cheaper than what international arbitration can offer. But they might also want the benefits of international arbitration, such as global enforcement. But some of the issues that I'm encountering as I'm doing my research on enforcement is, under the New York Convention, is it acceptable is it acceptable in the international arbitration system to accept some compromises on something that we consider to be fundamental? So, for example, could you have a dispute resolution system that doesn't have a legal seat? Could you have an arbitral award be enforced if the parties decide to contract out of due process? So that's some of the issues that I'll be focusing on the next part of my presentation on enforcement. So I mentioned already that one of the most significant advantages of the New York Convention is enforcement. That the idea is that you have an arbitral award and you can take it to over 150 jurisdictions around the world, and you can expect the local court to recognize that award and to enforce it against assets in that jurisdiction. I've identified, I think, 5 or 6 different ways in which enforcement issues might arise. I won't cover all of them today, but I'll pick out some that I think are particularly interesting and ripe for discussion. So one is, do you even need enforcement at all? There's a lot of online dispute resolution systems and digital dispute resolution rules that envisage that there will be on-chain enforcement. So previously I mentioned that there were the UK digital dispute resolution rule, which empower the tribunal to modify, transfer, cancel, change the digital asset directly. So you might be in a situation where the decision maker can enforce the award directly, and so the parties aren't in a situation where they need to go to a local court and to have it enforced. But you can also think of many situations where you might still need the intervention of the local courts. So for example, if you have an arbitral award and you want to enforce that award against assets that are not on the blockchain, for example, it could be a fiat currency, it could be a bank account, whatever shift, whatever it is. You might also require interim relief, for example, against a third party to refrain from taking some action. So there may still be ways in which, even if you have an online dispute resolution system, there might still be aspects of off-chain enforcement. The next issue under the New York Convention to consider is the requirement for an agreement in writing. So under the New York Convention and related rules, generally speaking, that agreement to arbitrate is interpreted pretty broadly, so long as you have something in writing. Many blockchain transactions are conducted by way of a smart contract, where some action, the contract self-executes in the sense that if some external event occurs, the contract self-executes. It's a bit of a misnomer because the smart contract is not by itself a legal contract that's understood in many parts of the world. And I think some might say that a smart contract might not even be able to have a traditional arbitration clause. So there are questions about whether whatever agreement it is that you have that supposedly gives that consent to arbitration, is that going to qualify as an agreement in writing for the purposes of the New York Convention? There's certainly been like a lot of interesting research out there about having some kind of hybrid contract where you have the smart contract written in code, and then you might have traditional or natural language text as well, where there is an express choice of forum. There's more issues we need to think about, for example, like code and the natural language are inconsistent, which one prevails. This is an issue that might come up in the context of an arbitral award that is made pursuant to an arbitration agreement that may not be considered in writing for the purposes of the New York Convention. The next topic I thought of is the identification of the parties. So in the metaverse, users interact as avatars, and in many ways, you don't have to disclose your legal personality. And I mentioned the digital dispute resolution rules in the UK, which allow the parties to remain anonymous vis-a-vis each other. But when you go to the court, typically many national courts will require the parties to reveal the true or the legal identities. So there's a question as well whether for enforcement purposes, parties will be required to reveal their legal identities. Is that going to be a requirement for a court that is being asked to enforce an award under the New York Convention? The next topic that might be an issue as well is the legal seat of the proceeding. Currently, under the New York Convention, it requires a territorial element, the idea that an arbitral award has a legal seat. This is to protect the integrity of the award because you have a national court that supervises the arbitral process. But then if you have a blockchain arbitration, there might not be a choice of legal seat in that arbitration. In that case, could that be an award that satisfied the territorial requirement under the New York Convention? We've seen at least a Mexico court case where the parties had agreed to resolve their dispute via a blockchain protocol, but they also had a procedure whereby an arbitrator would essentially adopt the resulting award as his or her own award that then I guess would be cloaked as having a legal seat, and the Mexican court actually upheld that, enforced that award. I'm not sure if in other contexts or by a decision by other courts would necessarily lead to the same decision. And also there's a very interesting model law for decentralized autonomous organizations, where the co-authors say that if you have sufficient due process protection in the model law, then you might be able to dispense with the concept of a legal seat entirely, because there are other ways to meet the same policy requirements for a legal seat. Okay, I see I'm actually running out of time at the 20-minute mark, so let me just flag two issues without going into detail. One is due process issues. So with some blockchain arbitrations, you don't have arbitrators who make a decision. You have jurors who are economically incentivized to make certain decisions. Would this be considered a violation of due process under the New York Convention? And would national courts allow parties to contract out of due process? And the final point is public policy. So under the New York Convention, some awards will be set aside on the basis of violation of international public policy. Some national courts in the context of arbitration have found, for example, that cryptocurrency or that transactions involving cryptocurrency may violate public policy. So again, you know, is this going to be a problem for the enforcement of awards? Would they violate public policy under the New York Convention? So I know I've thrown a lot of ideas out there, but I hope there'll be very interesting discussion for later. Thank you very much.
Thank you, ma'am. Thank you for easing us all into this concept of what exactly is the metaverse, and also touching upon as to what kind of disputes that may arise and enforcement issues pertaining to arbitration in the metaverse. Now, I'd like to introduce our next speaker for the day. Garrick, please move on to the next slide. Yes. Now, I'd like to introduce our next speaker for the day, Ms. Niyati Ahuja. So, it is an honor to have Ms. Niyati Ahuja today here with us. Ms. Niyati Ahuja is an associate in the complex commercial disputes and international arbitration practice of Steptoe and Johnson, New York. She is admitted to practice in India and New York. She also represents global corporations in complex international commercial disputes involving breach of fiduciary duties, shareholder and joint venture disputes, and investment disputes involving breach of stabilization and concession agreements. She has experience representing clients in the mining, energy, telecom, and banking industry. She also provides support in court proceedings in aid of arbitration, including discovery pursuant to 28 USC 1782, and recognition and enforcement of arbitral awards under the Federal Arbitration Act and the New York Convention, as well as the cross-border litigation proceedings. Ms. Niyati has graduated with Master of Laws from University of California, Berkeley, and Bachelor of Business Administration and Laws from University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University. Ms. Niyati Ahuja will be talking about how ADR mechanisms are actually feasible for resolving these disputes that may arise in the metaverse. Over to you, ma'am.
Thanks, Mayank, and thank you to the USLS ADR cell for inviting me. It's a pleasure to be back. It's from my university. There was no ADR cell back then. So I'm really pleased that you have created and you're doing such wonderful things. So today I'll be talking about how feasible are ADR mechanisms to resolve disputes in the metaverse. I'm going to be sharing my presentation. So can I just share my screen?
Yes, ma'am. You should be able to share your screen.
Do you see this?
Yes, ma'am. It's visible.
Okay. All right. So firstly, I'll be talking about what ADR mechanisms are there and which ones of them are very suitable for resolving disputes in the metaverse. And then I'll be talking about why it is feasible to use ADR mechanisms for resolving disputes in the metaverse. So what are ADR mechanisms? So the ADR mechanisms are basically different ways parties can resolve disputes without a trial or a lengthy litigation procedure. It typically includes early neutral evaluation, negotiation, conciliation, mediation, and arbitration. So for the purpose of this presentation, I'll be focusing on three of these, which are negotiation, mediation, and arbitration. Negotiation is basically something that all parties do before getting into either litigation, mediation, arbitration, anything. That's the first step they should take in resolving a dispute. It allows parties to meet in order to settle a dispute or just maintain their amicable relationships. Parties control the process and the solution, so it is less formal than other types of ADRs, which might have rules of arbitration or rules which are applicable to it. There's a lot of flexibility, as you might think, in negotiation procedures. then we move on to mediation. So mediation requires a mediator, and these are often people who have requisite expertise in a certain area, and that's why they are appointed as a mediator. It's a more passive role than an arbitrator, I would think, because they help the parties work out a settlement or agreement, and the parties are free to accept or reject it. Mediation is generally not binding, but with the Singapore Convention, it might be in the future. So for now, when parties choose mediation, they always choose for a non-binding mediation. Lastly, arbitration, which is my practice area, that is a majority of my practice. And so arbitration is more formal. It is similar to court proceedings. That is, it could involve discovery of documents. It has some rules of evidence, applicable substantive law as well as procedural law. So it's not like mediation or negotiation. I think the most important feature of arbitration is party autonomy, which is everything happens according to what they agreed in their agreement. So consent of parties is very important. It can be resolved by a single arbitrator or an arbitral panel, which is usually 3 arbitrators. One of them is appointed by each parties, and then the 2 arbitrators appoint the chairperson. So those are the 2 kinds of resolving bodies in arbitration. Arbitrators do not have to be lawyers. They can be experts in their fields. So that's why they are also very, very useful for resolving Metaverse disputes, which is because Metaverse is such a new area, that it would be helpful to have somebody who really understands what it is and can help in resolving suitable disputes. And under arbitration, there is 3 types of arbitration. It could be national or domestic arbitration, which is basically every country or most of the countries have an ADR Act or Arbitration Act, under which they indicate which kinds of disputes are arbitrable, how the domestic arbitration procedure should work. Secondly, it's international commercial arbitration, which is between 2 companies. This is usually confidential. It's between 2 companies in different countries. That's why it's international. Then there is investor state arbitration, which I think it might be less likely to see in the Metaverse arena for resolving disputes. So investor state disputes are basically when an investor invests in a state. For instance, McDonald's invests in India, and India takes away its property or starts using the McDonald's property for its purpose. You would then go for investor state arbitration. And moving on to the real question, are Metaverse disputes really resolvable by ADR? And the answer is a resounding yes, with the exception of, as you will see in very small letters, any disputes which are contrary to the public policy of the state. So every state has a public policy and which allows for certain kinds of disputes to be arbitrable and certain kinds of disputes to not be arbitrable, like a murder would not be arbitrable. So that would apply to Metaverse as well. Of course, at this stage, there are no rules or laws which have been made specifically for the Metaverse. So I think it's something that will develop, but I assume or I predict that such kinds of crimes will still not be arbitrable because states want to maintain their sovereignty over deciding such kinds of disputes. So why or how do you think how it will be feasible to resolve disputes in the Metaverse using ADR mechanisms? Because a lot of, as you might predict, that there's a lot of challenges of resolving disputes related to the Metaverse, which I will talk in my second part of my presentation. They can be resolved through ADR mechanisms. you will see there's certain challenges which can only be overcome through ADR mechanisms. That's why I think that it is very, very feasible to use ADR mechanisms to resolve disputes related to the metaverse. So what are the challenges of resolving disputes relating to the metaverse? Firstly, there is an issue in identifying proper parties to a dispute. As Lizzie mentioned in her presentation, the disputes could be between an AI robot who's in the metaverse and the metaverse. It could be with a party who does not want to identify him or themselves in real life. So there is definitely a difficulty in identifying proper parties, especially the ones who want to remain anonymous. There is an absence of legal regime. There are no legal rules which are adjusted for disputes in the metaverse. There is actually no specific laws for cryptocurrency disputes. So that has to be developed. So that is a challenge because there is no straightforward method to resolve disputes relating to the metaverse. There is no procedural or substantive legal regime, which connects to my previous point, which is there really is not much available yet in the just to resolve disputes. And this is not in a particular country, it's just globally. There is a lot of developments that need to be made to deal with all these metaverse related disputes. Lack of enforceability of judgment, that is something Lizzie touched on, and I will not delve into it, but there are on-chain enforcement mechanisms by which some platforms also require parties to have a certain amount of cryptocurrency available in case there needs to be enforcement. So that's like a prerequisite before the dispute resolution happens. Then there's a lack of proper understanding of metaverse amongst judges and also lawyers. I mean, just generally, it's such a new concept. So there is a lack of proper understanding and expertise over metaverse, which I hope we will achieve in the coming years. And this is not a new concept. Metaverse has existed or has been talked about since as far back as 2009. So we're still learning, and I hope people develop the relevant skills. And I mean, this program is basically something which is allowing all of us to understand what metaverse is, how disputes can be resolved, what are the challenges and how we can overcome them, so that we think about how these challenges can be overcome. So can these challenges really be overcome using ADR mechanisms? Yes, in my understanding of how ADR mechanisms work and can resolve metaverse related disputes, I believe the challenges can be overcome by using ADR mechanisms. Also, just as a disclaimer, there have been no international arbitrations yet in the metaverse or related to metaverse disputes, not that I have been a part of. There have been no centralized arbitrations, I should say, because there have been some decentralized arbitrations on platforms like Claros, which has some jurors. I think Lizzie touched on them, and I think Noor is going to touch on them as well. So the jurisdiction issue that I mentioned in my previous slide, parties can agree that the jurisdiction is the arbitrary. They can choose in their agreement that any disputes arising out of their use of the metaverse or any platform can be resolved through arbitration, and that will give the arbitrators jurisdiction to resolve the dispute. Parties can choose the applicable law and rules. For instance, Decentraland, which is a metaverse platform, in its terms of use, it provides for ICC arbitration seated in Panama City as the dispute resolution mechanism, which is already you can see that parties and platforms are already thinking they want to resolve their disputes through arbitration rather than litigation. So definitely this shows how people think that it is feasible, and it is often the chosen mechanism to resolve disputes. And Oculus has AAA, the American Arbitration Association's consumer arbitration rules, which are applicable to any disputes arising out of the use of the platform. The third thing is confidentiality of disputes. A lot of these platforms, as well as the users, want to keep their identity confidential. They want to keep the content of the dispute confidential, so that can be easily done by choosing arbitration, mediation, and also including in the agreement that any dispute resolution shall remain confidential. That is something which I think could be an issue with litigation proceedings, which are often public. And fourthly, admission to a particular bar is not necessary. That is to say that lawyers admitted anywhere in the world can appear before arbitral tribunals, which is not possible in litigation cases, especially in the US. Every state has its own bar. So you have to be barred in multiple states to be in front of a judge. So, and then lastly, but not leastly, arbitrators that parties decide to choose could have the requisite expertise, which might not always be possible when people go to a litigation proceeding, because the judges might not have any expertise in metaverse disputes. There is also specific institutional rules which can be and have been developed for specific crypto disputes or disputes related to the metaverse. For example, JANS, which is headquartered in the US, it has created its own draft rules for crypto disputes. Another issue that I mentioned before was identity of parties. Parties often want to keep their identities anonymous in the real world. That was the biggest challenge, because even arbitration rules provide for provision of the real identities, address, and all of that information before they accept a dispute to administer. So there are rules which have been developed, like I think Lizzie mentioned this one as well. This was the digital dispute resolution rules published by the UK Jurisdiction Task Force, which allows parties to remain anonymous. And then moving on to the next part of my presentation is how we can adapt ADR mechanisms to resolve disputes in the metaverse. Just as a background, I would like to, the disputes related to metaverse can be resolved either in the real world, or they can even be resolved in the metaverse. That is something I think is going to happen. It's going to make a lot of decisions for parties easier, because it will be much more cost effective. Parties as well as the legal counsel, witnesses, they won't have to fly around globally, at least for international arbitration or international mediation proceedings as well. So for negotiation, two parties can easily negotiate using their avatar sitting in different parts of the world. For mediation, neutral third-party users, a neutral third-party user means a person who's also a user of the metaverse, who understands the metaverse, can mediate these disputes. For arbitration, there could be centralized, which is something I have been talking about in my previous slide, versus decentralized arbitration. Decentralized is where there's jurors who help decide the dispute. That's how ADR mechanisms can be adapted to resolve disputes in the metaverse. As relating to investor-state arbitration, I think I mentioned that it is less likely to happen in the future, even for metaverse, because these states will have to have some sort of relation to the metaverse itself. And states have not developed as much, or are not as, they're a little bit wary about things that are not regulated, like cryptocurrency, as well as something like metaverse. So they're just trying to get to understand it and that's why I think it will be less likely that there are investor-state disputes, because there are bilateral investment treaties under which these investor-state arbitrations happen. However, the definition of investment in most treaties is quite broad, and it could include any kind of assets, which could be in the metaverse. That has not been tested yet. Some arbitration tribunal might decide that it is an investment and they have jurisdiction over such kinds of disputes. Just to give an example, which is contrary to what I have been saying and thinking, is that Seoul, which was the first major city to enter the metaverse, they had this whole ceremony where they entered, they decided to have a Seoul metaverse initiation. Barbados was also another country which announced that they have plans to establish the first metaverse embassy. This is something we could see happening in the future. I think it's going to take some time, but it could definitely happen. And in 10 years, maybe we will be dealing with investor-state arbitration, and we'll be dealing with those disputes in the metaverse. So I think that is all that I have to say today. My concluding thoughts are, I would like to quote Ethan Cash, who mentioned that the power of technology to resolve disputes is exceeded by the power of technology to generate disputes. And for a long time, we were thinking technology has developed so much with ODR that we can resolve disputes just by using ODR mechanisms. But the technology has also developed as much to give us metaverse, which has already created a lot of IP disputes and is going to generate many more disputes as it keeps getting developed. And another question, or perhaps food for thought, is maybe there's going to be a separate metaverse legal system where all of us will want to be barred in, and that's just going to be the way forward. I am not sure, but we are yet to see. Thank you so much.
Thanks a lot, ma'am. I think you've actually sparked a lot of ideas, because a lot of students are watching us, and maybe someone comes up with the legal metaverse space that we just talked about. So it would indeed enriching and refreshing the ideas and the thought exercise, I would say, at large, about how ADR techniques are feasible for disputes arising out of metaverse. So moving forward, I'd like to introduce our third speaker for the day, Ms. Noor Nicholas, and it is a privilege to have Ms. Noor Nicholas, who is an associate at Foley Hoag LLP, New York, and her practice focuses on public international litigation, investor-state arbitration, and international commercial arbitration. Ms. Nicholas has experience representing sovereign states, state-owned entities, and private companies in numerous arbitrations conducted, namely under the rules of International Center for Settlement of Investment Disputes, the UNCITRAL, the United Nations Commission on International Trade Law, and International Chamber of Commerce. Without further ado, over to you, Ms. Nicholas.
Thank you very much. Hi, everyone. And I join my colleagues on the panel in thanking all those who have organized this event and who have invited us. It's a great opportunity for all of us to learn just a bit more on this topical and increasingly important topic, which is the metaverse and how it crosses over with alternative dispute resolution. So I'm supposed to be talking today about what smart contracts are and what types of disputes they generate in the metaverse. So first, what are smart contracts? Smart contracts is a term that is used to describe computer code that automatically, which means without human intervention, executes all or parts of an agreement and is typically stored on a blockchain-based platform. But it's important to first clarify that smart contracts themselves are not the legal agreement. They actually translate the legal agreement made between the parties into an executable code. So in other words, it's basically the means to execute and perform a contract that the parties choose. And the terms of many contracts can actually be written in programming languages that could be communicated to a machine. And the reason for that is that the performance and enforcement of a contract essentially can be boiled down to conditional statements, which are foundational to computing. For example, if a certain triggering event occurs, a certain outcome has to be produced. That's sort of the formula. And when those triggering events occur, the smart contract will automatically execute the terms of the agreement. Now, a very popular analogy that circulates, and which I take no credit for, is one about the vending machine. So basically, you enter the code for an item on display. If the vending machine has already received the money, it will dispense the item in that slot. If the vending machine has not received enough money, then it displays the item's cost. That is a smart contract. Of course, there are other examples in many areas of application: finance, production and supply chains, insurance, healthcare, sharing economy. And I'll use just two simple examples of their use in practice. Imagine a sales transaction when a product arrives and is scanned at the warehouse. A smart contract can immediately trigger requests for the required approvals. And once the approval is obtained, immediately transfer funds from the buyer to the seller. Now, another example, in a transaction involving internet-based services. When a required payment is not received by the deadline, a smart contract could immediately deny the user's access to such services, or even automatically impose a late payment fee on the user's bank account. In general, there are two types of smart contracts. On the one hand, you have code-only smart contracts, where the code is the only manifestation of the agreement between the parties. And these smart contracts are ones that digitally record and execute the parties' agreement without the need for any conventional, traditional text-based contract. And on the other hand, you have ancillary smart contracts, where the code only complements a traditional text-based contract. So these smart contracts only serve to execute certain provisions of the traditional text-based contract while completing them. And to name just a few benefits that smart contracts are increasingly providing everyone. First, you have certainty of outcomes. Smart contracts could offer a way to substantially reduce the need for litigation in courts. And that's because when parties commit to using self-executing contracts, they bind themselves to the rules and determinations of the underlying codes without necessarily exposing themselves to third-party adjudicators. Second, removing the need for third parties also helps organizations save their costs. Three, they ensure enhanced accuracy and efficiency, because the execution of the process is immediate after the certain triggering events or conditions are met. So there's no need for paperwork to delay the processing time. There's also no room or time to start, making interpretations. Smart contracts are also immutable, which means that they provide security, because parties can just simply amend the contract without first mutually agreeing to incorporate the possibility of amending it. And second, it also, in a way, provides security because it prevents hacking. Because so each entry on the blockchain is actually registered in the previous and succeeding block in that ledger. And to change one single record, the entire chain would need to also be changed and hacked, which is in theory very difficult. Which is why, in theory, again, this makes the contract very safe. But in practice, and I'll get to that in a bit, in practice, it's true that blockchain has not been entirely from hacking. And finally, one last benefit I would mention now is that smart contracts actually removes the need for trust between the contractual parties. Just because the contract is automated, you do not need to rely or trust the other partners in the relationship. Now, some of the disadvantages and cons of smart contracts are also quite interesting, and they're very important in practice, specifically in the metaverse context. And to present just a few, smart contracts don't necessarily align with the manner in which businesses typically operate in the real world. In the real world, as all of you might be already aware of, there's always room for flexibility. A party might be willing to accept exceptionally partial performance as full performance, and that's for different reasons. One, because there's an interest in preserving a long-term relationship with the other partner, or because a party pragmatically determines that a partial performance is just preferable to no performance at all. And the objectivity of the code doesn't really reflect those realities of how contracting parties react and interact with each other. And another disadvantage is that amending a smart contract is not as easy as just the parties writing an amendment or altering their course of conduct. They, again, don't offer that flexibility. And given that they are immutable, modifying a smart contract is actually far more complicated than just modifying a standard software code that's not on the blockchain. It actually is increasingly more expensive. And it could also increase the margin of error if the parties don't accurately reflect the modifications they really want to make. Similar challenges, of course, exist if parties were to decide to just terminate a smart contract. Assume a party just discovers there's an error in agreement, which is, I wouldn't say frequent, but it could happen in practice. Or, for example, assume that a party concludes that just fulfilling its stated obligations will be far more costly than it had expected. And if we were in a traditional text-based contract setting where a party can engage in, or at least threaten, let's say, so-called efficient breach, which means knowingly breaching a contract and paying the resulting damages, if they determine that the cost of performance is just greater than the damages it causes, you can't do that. You don't have the same self-help remedies in the metaverse. Or, for example, if party in real life just threatens the other party of ceasing performance of a contract in order to, let's say, compel the other party to the negotiating table and to find an amicable solution, that also is not available in the metaverse because contracts are automatically executed. And also, it could happen that parties to a contract, as they're negotiating it, well, first, they're not able to address every conceivable eventuality in their relationship. They might also choose to leave certain issues unresolved or ambiguous, and to have some flexibility if they want to have a certain concept in their contract evolve with time, with best practices, or if they just want to have the flexibility of, with time, making sure that a certain interpretation of the contract is made in their favor, not the other way around. And I'd say importantly, smart contracts, and that's another disadvantage, smart contracts don't actually guarantee payment. Of course, one benefit that's constantly touted of smart contracts is that they can automate payment without the need for notices, collection expenses, going to court, obtaining judgment, enforcing that judgment. But the reality is that it all really depends on whether the underlying funds are available, which then in turn depends on the will of the debtor. So, you have this contract, it could be executed theoretically, but the debtor doesn't have the funds. That's as far as the smart contract can go. So there you might actually need to go to traditional courts and take that smart contract with you and try to see if it's enforceable before the court. So smart contracts don't really eliminate the risk of non-payment or of payment disputes. They do render them more efficient in general, though. And finally, as I foreshadowed earlier, smart contracts also introduced one additional risk that doesn't really exist in most text-based contractual relationships, and that's the possibility that the contract could be hacked or that it could contain a programming error. And it has happened in the past, so the parties have to just and maybe allocate the risk and liability of unintended coding errors, or the resulting exploitations by one of the parties of this unintended errors. Now, moving on to the metaverse. And as has been already explained earlier today, and I'm not going to belabor this, the concept of metaverse is this virtual reality where parties are expected to work, play, learn, shop, interact with each other, conduct transactions. And it seems that smart contract is actually highly efficient and useful for the metaverse context. And many metaverse platforms, if not all of them, such as Decentraland, allow for the use of smart contracts between the users in order to trade NFTs, land, etc. However, the use of smart contracts as part of this metaverse presents many challenges. And in reality, these challenges already exist in the real world, but perhaps they're magnified in the metaverse. And first type of dispute that I would think of is actually due to two things simultaneously. One, the limited scope of smart contracts, and the other is actually also the limited nature of the metaverse. Smart contracts are limited to monetary obligations and term limitations. They don't allow users to provide for more complex rights and obligations. They're really best suited for two types of scenarios. So payment of funds upon certain triggering events, or financial penalties if certain objective conditions are satisfied. But broader than that, they don't, for example, specify what the governing law is or the forum and jurisdiction where the contract is supposed to fall under. They don't provide dispute resolution mechanisms. So their functions are really rudimentary. Now, conceptually, of course, it's always possible for the parties to try to include such clauses in their code, but that would significantly increase their cost of the transaction. And naturally, when you're in the real world setting and you have a smart contract, whenever you have this lacune, because you're not sure, your code doesn't provide the governing law or the jurisdiction, you naturally tend to go to the default governing law and traditional courts. But you don't have that in the metaverse specifically. It's really unclear what law would govern the contract or a potential dispute, because by its nature, a metaverse does not know geographical boundaries. So there's no, as Ms. Chan has said earlier, there's no legal seat, there's no default substantive law, there's no conflict of law system. Now, it's been floated whether metaverse could assert sovereignty, and we've just heard it in the previous presentation that, might we have this separate sui generis metaverse legal system? It has been really floated, that idea, but so far the answer is no. You need a sovereign to have a legal seat. You need a sovereign to have a jurisdiction. But we'll see where technology takes us. But for the moment, the answer is just no, which is why it presents many uncertainties and difficulties when just dealing with the metaverse. Now, another category of dispute or issue that particularly arises in the metaverse and pertains to smart contract is just basically any type of post-transaction dispute. And again, this exists in real life. Once a code is written, it must be executed. There's no room for interpretation, no room for reflection on the scope of obligations prior to executing them. So smart contracts naturally just increase the risk of post-transaction disputes, because the parties realize after the fact that they actually dispute the interpretation of a certain term in the contract. But the good thing about a real-world setting is that the aggrieved party can just go to its court in order to remedy the contract that's already been executed or is in the process of being performed by the smart contract. And the remedy would be always after the fact, to kind of undo or alter the agreement in a certain way. And again, here, there's no equivalent in the metaverse setting in particular. I know that some might think that you might not need to have, why would you have these post-transaction disputes if you're in a smart contract setting? And I would get that reaction because in general, if you're programming or writing a code, you usually have less room for ambiguity, because the code is usually complete, predefined, very comprehensive. It's not made in human words, so there's way less room for ambiguity. But nevertheless, ambiguity will always virtually exist. So post-transaction disputes could always happen, and they're much more difficult to happen in the metaverse, separate, just in the metaverse than in the real world. And finally, smart contracts in the metaverse engender the risk of a third very important type of dispute, and that's enforcement. It's already also been foreshadowed. And to recall, smart contracts do render performance more efficient, but again, they don't altogether eliminate non-performance through non-payment. This means that, again, to compare, in the real world setting, the intervention of public law officers is actually needed, even though a smart contract is theoretically enforced through its own terms and its own automated mechanisms, but that is possible. And the typical legal action for breach of contract would involve, again, an aggrieved party going to a court to demand money damages, restitution, or specific performance. But here again, there is no such secure alternative, only in the metaverse. So it really all boils down to this nature of the metaverse. It's because it's virtual and because it knows no geographical boundaries that contracts are not grounded in a certain jurisdiction that provides some sort of security or legal certainty to the users. And that's why for the moment, it's always been encouraged that in addition to having a smart contract, tested out, explored in the metaverse, parties should always opt for a classic traditional text-based contract on the side, allowing the users, well, first to know who the counterparty is, or at least to validate, the jurisdiction, to identify the applicable law and the dispute resolution mechanism. Because at the end of the day, the reason why parties and users enter into contracts with people they know or they don't know is because of the security and the certainty that obligations and commitments provide. So if you don't have that, you're basically removing the underlying need for a contract. But all of this, again, is to say that right now it's just very uncertain, and we can always, explore and keep informed of where technology leads us, where the lawyers might lead us, because, creative enough, we might find solutions to all of these. And with that, I conclude my presentation.
Thank you, ma'am. I think the topic itself, smart contracts and how perfect they may seem, but the challenges that were highlighted by you and the inherited disputes that you can already overlook that can arise in the future does paint not much of a rosy picture as we might have had before coming into this session. But as you said rightly at the end, that there is room for innovating in this space and to come up with better technologies that are able to, at the end of the day, help with justice dispensation. So with that, I'd like to thank you again. Thank you once again, Ms. Noor Nicholas. And moving on to the final speaker of the day, it is my privilege to be able to introduce to you all Mr. Neeraj Mudha. Mr. Neeraj is a barrister and arbitrator at 39 Essex Chambers in London, England. He specializes in commercial, construction, and property litigation and arbitration. His international practice is focused on India and the Middle East, and Mr. Neeraj is currently instructed as a sole advocate in the institutional arbitration proceedings seated in Doha. Just a second. Seated in Doha with a value of excess of 400 million USD. Mr. Neeraj is also a fellow of the Chartered Institute of Arbitrators and is a panel member for several institutions. He has been appointed as an arbitrator in more than 25 disputes till date. Mr. Neeraj Mudha will be talking on the use of ODR and allied technologies in cross-border disputes, smart contracts being used for dispute resolution, and resolving disputes pertaining to crypto transactions, which again are cross-border in nature in the metaverse. Over to you, sir.
Thank you very much for that kind introduction, Mayank, and good evening to everybody. It's a pleasure to be talking with you at this online conference. I'm very grateful to the university, the esteemed and respected professors, and the very conscientious student organizers of the ADR cell for inviting me to talk. And thank you also to the students for attending. I'm also very pleased to be sharing this platform with my esteemed colleagues. I'd just like to share my screen, if I may. Hopefully you can see the front slide of my talk. I'm going to be talking on several topics this evening. I'm conscious that there is some crossover between the matters which are the subject of my talk and also the topics of my colleagues who've gone before me and the talks that you're going to hear also tomorrow. So I'll try not to trespass onto those topics. The areas on which I'm going to talk are as follows. First, I'll talk a little bit about the use of ODR online dispute resolution and allied technologies in cross-border disputes. Second, I shall touch on smart contract dispute resolution. Ms. Nicholas has already spoken expertly on this topic, so I'll focus on smart arbitration. Thirdly, I will talk about crypto asset dispute resolution. There's been a growing interest and litigation surrounding crypto assets within the past 1 to 2 years in the real world, and I'll pick up on some key themes and principles and how these may translate over to disputes in the metaverse. Before I start, though, on ODR, it's worthwhile to just keep in mind 2 general points. First, there's a lot that can be said about each of these topics. I think you could probably fill a conference with one of these topics. So my focus is going to be on the metaverse, also known as Web3, or the Internet of the Future, virtual universe, metaverses, as Elizabeth pointed out earlier. All of these words collectively describe the virtual worlds that are beyond the internet that we currently have, or that most people are used to, Web 2. Second, these concepts and features are relatively new. There's very little case law, although disputes are being litigated and some themes are emerging. So inevitably, some of what I say is conjecture, but that's not going to stop me trying to make some predictions. The first topic then is ODR. Now, what is ODR? ODR is online dispute resolution. This encompasses at one end of the scale, fully automated adjudication of disputes. At the extreme, it may require no human input whatsoever. It could be entirely reliant on artificial intelligence. At the other end of the spectrum, ODR means only the use of online systems and technologies to facilitate dispute resolution. So that's the type of ODR that most of us, including me, will be familiar with in the realm of Web 2. That's the current incarnation of the internet, which is characterized by big tech corporations and centralized platforms. So we have to be clear what we're talking about. We're talking about ODR, meaning potentially a wide range of things. It's very important to be precise. It's also worth pointing out that ODR is still quite new as a concept. The term itself was only coined about 20 years ago. In contrast to that, the term metaverse was first invented or found in the early 1990s. So it may be surprising that the idea of virtual worlds is actually older than the concept of online dispute resolution, even though ODR feels like it's been around for a lot longer. Maybe as a result of that, there is no universal standard or set of procedural rules for how ODR operates, as there are with real-world arbitration. UNCITRAL working group on cross-border ODR was only established in 2010. It's published guidelines and principles on the administration of consumer and business disputes online. And these set out the initial stages from submitting a dispute to online negotiation, facilitated settlement, and then online adjudication. But these principles are still fairly general and high level. However, ODR has had some success. It's been used to great effect in high volume, low value business to consumer transactions. So think, for example, PayPal, or as Elizabeth mentioned earlier, eBay's Resolution Center. These are centralized ODR platforms. So that's a key feature between real world dispute resolution, where we have institutions largely dealing with arbitral proceedings, for example, and courts, which are also institutional, and online ODR, online dispute resolution. They're both characterized in this sense by centralized platforms. And I'll come on to how that's different to potential dispute resolution in the metaverse a little bit later. But there are problems. There are restrictions on ODR. It's not mandatory in many e-commerce disputes. So, for example, in the UK and the EU, it is optional for a consumer. Consumer doesn't need to go down the route of ODR. And it's also a key feature, an interesting feature actually, over the last 1 or 2 decades, that whilst online transactions, domestic online transactions have increased significantly, cross-border e-commerce transactions have increased much more slowly. So just to give an example, Amazon, eBay, these are very popular portals, very popular platforms within the domestic setting. So within countries, but actually cross-border electronic transactions have not really taken off in the same trajectory. And that may be another reason why ODR hasn't really developed in the same way as many people predicted a decade ago. The issue I'd like to focus on and address here is how ODR will play out in the metaverse. And the key question I have is, will it be superseded by virtual or artificial intelligence dispute resolution, or is there a role still for ODR? My view is that ODR as we currently know it will be left behind. We're already seeing new forms of dispute resolution which are fully automated and virtual. The disadvantages of ODR, so the lack of face-to-face involvement, for example, and its summary nature, might well be overcome by a decentralized system within the metaverse or metaverses, in which parties and witnesses can attend and participate virtually. So this is one difference between ODR and real world, where you don't get to meet face-to-face because it's all online, maybe done on documents only, maybe very quick, it may have those advantages, but you miss the interaction which the metaverse could provide. And I consider that disputes will continue to increase. There'll be a significant proliferation of disputes as the metaverse and metaverses develop. There are two reasons for this. First, the real world, our physical world capacity for dispute resolution is limited. We're limited by who we have, the people we have, and the institutions that we currently have. There are strained resources, there are delays in these systems, both in court, national court systems, and even in arbitration, and it's expensive. So I think there is scope, if there can be cheaper, more cost-effective and quicker resolution in the metaverse, there is scope for dispute resolution in the metaverse. Second, it stands to reason as these virtual worlds develop and begin to dominate the spheres of business, entertainment, and leisure, the greater volume there will be of interactions and transactions between people in these virtual worlds, not only between people represented by their avatars or their anonymous identities, but also the real world actors who control them. So it's essentially opening up a different series of worlds where there is a mushrooming of potential disputes. Moving on to artificial intelligence, I think we're likely to see more artificial intelligence in cross-border online dispute resolution. Just taking a step back, nobody yet has spoken on AI. AI is a method, artificial intelligence is a method by which a machine is fed data, the data are processed, and then the machine outputs a response or answer, depending on the program or whatever it's been required to decide on. So at a relatively basic level, a machine may be able to recognize and measure speech and language, or describe and analyze objects or images. Machines, in this example, analyze and store the information, then execute the task. At a very more advanced level, we have machines that are capable of observing patterns, of picking out recognition, of repetition. They're able to self-correct, they're able to learn from their own errors and rapidly produce what we can prove are more consistent and accurate outcomes. This is what I mean then by machine learning or deep AI. And there are numerous benefits to using AI to resolve disputes in the metaverse. Artificial intelligence is rules-based, like law, it's based on code, as opposed to the language of law that we use, depending on where we are. Deep AI has the capacity, the ability to rival human intelligence. There are even suggestions from some places that AI will develop to a stage where a machine will have legal personality. This is not so far-fetched, actually. Already there are debates in developed jurisdictions about whether animals or rivers or other features of the natural world should have legal rights. So why not machines which can learn from their experience and improve their decision-making? However, as with all things, we'll be aware as lawyers and student lawyers that there is always the flip side of the coin. There are disadvantages also with artificial intelligence in the metaverse. Disputes can be multi-layered. Outcomes are not always binary. Some places aren't black or white, or they're in the middle, they're a shade of grey. One can wonder also whether a computer, no matter what its processing power, can ever be capable of human emotions of empathy or forbearance, or producing very reasoned and nuanced legal decisions, or exercising discretion or granting indulgence if that's what justice requires. So whilst AI is fast developing, hand in hand really with the development of Web3, it's still currently, in my view, some way from being able to take over human judicial decision-making. Finally, then, there are new decentralized systems for the resolution of disputes in the metaverse. And one on which I would like to focus, which we've already heard a little bit about from my colleagues, is peer-led dispute resolution. And there are a few companies which are exploring this field. I think Claros was mentioned, there's also Aragon. These are decentralized court systems in the metaverse, built on Ethereum. They crowdsource for anonymous jurors, so that a juror will stake their tokens, their coins, and a juror will be selected at random to decide on a dispute. And as has already been mentioned, these potential jurors are incentivized to vote because they get paid. They get paid if they vote a particular way. Now, I'll come on to that in a second. But what is at the heart of these decentralized systems is game theory. So jurors collect fees, or they get to keep their stake and get a bit extra if they vote with the majority, but they lose a percentage of their stake if they vote the other way, if they make the wrong decision. So that's a rules-based system, but that is actually somewhat alien to lawyers. We're used to applying law, possibly applying equity or other principles when deciding a dispute, not game theory. There are drawbacks to this. The majority is not always right in law. Gut instinct isn't always to be trusted. Jurors potentially have no legal training at all. Is it fair to have a virtual resolution without a trial in a virtual world, which might have automatic consequences, because it may be somebody has paid money into an escrow account, and depending on the decision of these online jurors, that money's gone. There's potentially no right of appeal, although these systems do have some limited rights of appeal. And there's also a question that was raised earlier by my colleagues on principles of independence. Is it fair, is it right to have a juror in a dispute, commercial dispute, who is incentivized in this way? There's a real concern here that we are opening up justice. We're opening up justice, how it's seen to be done, and also the participation in justice. But should justice be a form of recreation in this sense? Can someone just go onto their mobile phone, onto their tablet, and make decisions in this way for money, when actually the business of lawyers is justice, whether it's the truth? Some people dispute that, or whether it's finding the best case, the best arguments. It's a very different outlook, and I think we need to be, as students and as practitioners, we need to be alive to these alternative court systems. Because of these criticisms and drawbacks, I think it's wrong to focus on ODR as a panacea for dispute resolution. Some people think ODR is just a fad. Holograms and headsets don't really add value to the experience, they can detract from it. There is maybe some truth in that, but whatever the case, there are serious opportunities here for the growth of ODR in a different form, as I've said, in the metaverse. I'm now going to move on to smart contract dispute resolution. Mr. Nicholas has already spoken expertly about smart contracts and the types of smart contract disputes that can arise. So I'm going to talk really just about smart arbitration, and there are 3 points. We're talking here about smart legal contracts which provide for disputes to be resolved automatically by arbitration. So either by human arbitrators or possibly by robot arbitrators, automatic selection of arbitrators, publication of results, which are essentially awards, and their enforcement. So it's arbitration, but not as we know it. I think we'll see a number of issues that will arise with smart arbitration in the metaverse, and I've identified 3 issues in particular. First, there may be jurisdictional issues. So the sorts of questions that have already been raised by my colleagues will continue to pop up. These are, where was this smart contract formed? What's the proper law that applies to the contracts that underlie it? Where is the arbitration, if there is to be an arbitration, seated? Which law applies to it? Which law applies to the smart legal contract? It may be that the code doesn't cover these concepts or cover these issues. In my view, this is likely to lead to a greater development of transnational principles, in the same way that there are disputes within the arbitration community about transnational principles and whether there is a philosophy or principle theory of international arbitration that cuts across different jurisdictions. The metaverse gives practitioners the opportunity to develop these transnational principles. It may also be that there will be automatic execution and enforcement of awards. I may differ from some of my colleagues on this, but on the face of it, yes, I can see difficulties with enforcement, and the New York Convention in particular, with enforcing disputes resolved in the metaverse in the real world. But what if the rules of entry into a metaverse, into a single virtual world, require that participant to deposit funds or to agree certain terms and conditions as a prelude to entering into this virtual world? What if they have to deposit sums or give details of the wallet of Bitcoins or whatever it may be that they have? It could seem to me that where there is a dispute that arises and there is a procedure, arbitral procedure or whatever kind of dispute resolution procedure, that could have an automatic execution. So we don't need to deal with the issues of disputes drifting across into the real world and there being difficulties of enforcement in the real world. I say real world, I'm talking about our world, but I'm using that term to distinguish that from the virtual worlds of the metaverse. Second, will there be greater transparency? And will that be to the expense or for the loss of confidentiality? If there's provision for arbitration, will we have more transparency in the selection and appointment of arbitrators? Will parties be able to view the records and prior decisions and awards rendered by arbitrators, all through a blockchain database? Perhaps feedback on arbitrators will be available in an open way. How long an arbitrator has taken to render an award. It's maybe a worrying thought for arbitrators like me, but maybe it's the democratization of data, and this is for the public benefit. There are lots of criticism at the moment of investor-state arbitration and the secrecy of arbitral proceedings. This could open up and democratize those proceedings in a way that is potentially very good. And third, undoubtedly, there will be room for disputes, as I've already said, and disputes about disputes. Like any language, code is not perfect. Coding can go wrong. Smart contracts can be hacked, although as has been pointed out already, blockchain technology makes that much, much harder. But we know that algorithms, the code underlying the contracts that we're talking about, aren't infallible. We've seen examples of algorithms that discriminate. In the United States, there are search and advertising algorithms that are under scrutiny for this very reason. And you may also have heard about concerns regarding racial bias in certain experimental artificial intelligence self-driving systems. So in my view, these disputes will arise and continue to arise and develop, but they will be rooted in our face-to-face world because they concern the code and the algorithms. I think Elizabeth used the phrase building blocks. They're the building blocks of the metaverse rather than within the metaverse itself. Finally, I'm conscious of the time, but hopefully I'll be able to spend 5 minutes looking at crypto asset dispute resolution. I'll say a few things. Crypto assets, firstly, what are they? Crypto assets are digital assets which have value and which are capable of being accumulated and transferred. They are intangible and they're encrypted in some way so as to introduce a level of security. That doesn't mean there aren't possibilities for fraud, for example, which I'll come on to with the cases that I look at. But they use a decentralized distributed ledger so that the ownership and transaction of relating to crypto assets and cryptocurrencies in particular can be recorded transparently and securely and potentially also fully anonymously. Now, as with smart contracts, there are different flavors of crypto assets. You have Bitcoin and cryptocurrencies at one end. They're used for payments. Some people use them for investment. Although I know that the Financial Conduct Authority in the UK advises that if you buy crypto assets, you should be prepared to lose all of your money. So there are people who invest, but clearly that is very risky. But this area is completely unregulated, almost completely unregulated, certainly in the UK. There are some money laundering regulations that apply, but otherwise it's the Wild West. Likewise with NFTs, non-fungible tokens, these are digital proofs of ownership of virtual assets. And these are also completely unregulated at the moment in my jurisdiction. And at the other end, you have security tokens, which operate like shares or electric money, and those are regulated, but I'm not focusing on those. I'm focusing on the crypto assets within the metaverse today. In England, there's been some uncertainty until quite recently about whether crypto assets are or should fall within the definition of property. There's at the moment no legislation on crypto assets here, but in the last couple of years, we've seen the rise of crypto asset disputes in the High Court in England, and this gives us an indication of what's on the horizon. So in one case, the first one there of AA and persons unknown, this was a claim by an insurer against unknown people to whom it had paid a ransom payment because the insurer's client had their IT systems hacked. And Mr. Justice Bryan, in that case, held that the cryptocurrency could be treated as property because it is, I quote, definable, identifiable, capable in its nature of assumption by third parties, and has some degree of permanence. Now, that is despite Bitcoin not falling within the traditional boundaries of what constitutes property. It's not something you can see or hold, and it's not a right that you have. And that's the traditional classification of property, two different classifications of property in English law. In the case of Wang and Darby, that was a transaction where the claimant and defendant essentially did a currency swap. They swapped one cryptocurrency for the other and agreed to swap back again 2 years later. Why they did that precisely is unclear to me, but that's the deal they came up with. And in that case, the Deputy High Court judge held that fungible and non-identifiable digital assets constitute property capable of being bought and sold as well as held on trust as a matter of English law. And in that case, actually, it was found that there was no constructive trust because the transaction involved an agreement that the parties would exchange these currencies later. So there couldn't be a trust imposed because there was always inherently an exchange in the future that was anticipated. But nonetheless, again, another case in which very recently, relatively recently, the court has held that these cryptocurrencies are property. And in Fetch AI, the judge in that case, Deputy High Court judge, held that the lex situs of a crypto asset is a place where the owner of the crypto asset is domiciled. So if someone has crypto assets or the real owner has crypto assets, it's their place of domicile, which gives the gateway into proceeding in English courts. And in that case, the judge granted injunctive relief and a worldwide freezing order. So again, that case was rooted in the real world, not the metaverse. None of these cases really deal with inside the metaverse because, as my colleagues have pointed out, it is so new. It's also worth pointing out these are all interim decisions. So in some of them, the court held only had the benefit of submissions from one party, from the claimant. So we still await a fully argued and reasoned decision on which will give a binding precedent to us. But we can see that the English courts have muscled in really quite early to hold that common law rules and common law principles on property apply to crypto assets. They're likely to be treated as property in English law, or at least in the nature of property, which has the same effect. By contrast to that, the metaverse is still conceptually opaque in many ways and almost wholly unregulated. So the metaverse has a lot of catching up to do in that sense, because as things stand, it's difficult to see how these disputes, if jurisdiction has been decided to be in the real world with the ownership and transfer of these assets, it's difficult to see how that leaves very much scope for disputes in the metaverse. However, that's not to say that there won't be disputes in the metaverse that are resolved in the metaverse. There are IP disputes related to the purchase and transfer of crypto assets within the metaverse, and there's no authority yet on transactions within the metaverse itself or within a metaverse itself. So as I see it, there is going to be a blurring of boundaries between the real world, our physical world, and disputes being resolved here, and disputes being resolved in the metaverse, and disputes may drift in and out of both systems. It's really an open question whether, if you go into a virtual world like Decentraland and you buy virtual assets or virtual goods and services, do they have the same status and quality of assets and goods in the real world? Or have you already given up your rights to claim that because you have purchased tokens and essentially you've got a benefit, a value already? So your transaction is really in the real world of purchasing those tokens, and if you're upset about the service that you've got or the land that you purchased virtually, that's not a dispute that's relevant to the metaverse. You've bought and purchased service in the physical world. So that's a question that's likely to come up. My view then, just wrapping up, is that as I mentioned, the metaverse seems to be a bit like the Wild West. we're mixing unregulated crypto assets with an unregulated metaverse, and that's a recipe for disputes. Again, good news for lawyers, but also we'd like to try and understand why these disputes happen and how best to resolve them for the benefit of our clients. With things as they are, crypto assets are treated as real-world property. So dispute resolution will be focused in the real world until the metaverse catches up, in my view. And it remains now to be seen whether there will be new dispute resolution processes which regulate intra and inter-metaverse transactions. That's another concept. It's, what about transactions between different metaverses? It's an unanswered question. And I think that ODR and smart arbitration in particular, using AI, will fill this gap and will help the metaverse to develop these systems. Thank you very much.
Thank you, sir. I think you were able to cover a lot within the time that was allotted. And again, to be able to understand that the disputes that arise even before we interact with the metaverse and the disputes that may arise when we actually get into the metaverse are completely different scenarios. But yet again, they do stem out of something that actually happens in the physical world. I think that to be able to look at this proposition on which we are conducting this conference today is really refreshing to the participants, and it provides an outlook through which we can also understand that how technologies like ODR could benefit us in our crusade to be able to make justice more accessible and efficient. Moving forward, I would like to I would like to I would like to address the participants that we'll have a short break of 5 minutes. And in the meantime, I'll request my colleague, Mr. Dipanshu, to please share the link for a Google form. And I request the participants to please fill the Google form for the purpose of attendance so that we can keep a track of people who attended the day one of the conference. So now we're moving into the moderated general discussion. The participants are encouraged to send in their questions for the panelists through the chat box. And if a participant would like to directly ask any question to the panelists, we might be able to take 1 or 2 questions for that matter. And for that, please raise your hand using the raise hand feature of Zoom. Whereas I would also like to announce that Ms. Noor Nicholas and Ms. Elizabeth Chan would not be able to continue for the discussion as they have some prior commitments which they need to attend to. We try to keep this session short and crisp, but again, Mr. Neeraj and Ms. Niyati, we'd also like you to engage as much as possible amongst yourselves as well. So with your permission, shall we begin? Okay. So welcome once again, everyone. And kicking off the moderated session, I'd just like to put it up to both our speakers that it has been talked at length that how the resolving disputes in the metaverse could actually become counterproductive because of the nature of the very resolution. It is not under any sovereign authority, and it can also actually become someone's game because people get to bet on, and it's up to the stake whether justice is delivered or not. But at the same time, again, as Mr. Neeraj himself pointed out, that it can also democratize a process such as arbitration, which is very tight-lipped. So I'd like to propose to the speakers as to if at all do you think there is a possibility, just like big tech operates around the world. For example, in EU, you have GDPR guideline. In India, you have IT Act, which covers the aspect of privacy. So with regard to the issues of privacy and with regards to the issue of exploitation of people using that platform, could there be such homogeneous guidelines around the world developed by the states themselves, which would actually cover how the metaverse or the metaverses work, but still the platform is based in one country, one jurisdiction. The people that use it are across from various jurisdictions, just like any social media platform today. But to be able to hold that metaverse platform accountable, or to be able to make sure that even if a process like blockchain arbitration is being conducted, it does not fall into the trap of, again, the example was given by Mr. Neeraj that uh, people are bidding on it and it is up to someone's stake what the kind of justice they get. So could there be policies, could there be frameworks by the states themselves to regulate it to that extent, but yet keeping the functionality and efficiency, the cost efficiency, the ease of usage, right, and to make it more democratic, both at the same time. So I'd like to have the thoughts of Ms. Niyati and Mr. Neeraj, both of you, on this.
Shall I chip in first, if I may? Thank you for that question. It's a very good question. I think this is probably the key issue at the moment. It's important to note, I think, that one of the main advantages, that's perceived advantages at least, of the metaverse is that there isn't this regulation. There aren't the rules. People are free users, in fact, not the big tech, not the big corporations or the creators of these virtual worlds, but the people are free to create what they wish. And if given the opportunity, many people, I guess, would not want regulation. That's the key feature, the advantage. It's an escape from the real world where there are rules and regulations and norms. So the first question is there going to be an appetite for this type of regulation? And it may be that in some of these virtual worlds, there isn't an appetite. And again, I go back to the point I made before, we as lawyers and student lawyers like rules because this is what governs our society. We have rules-based systems. So we are, I think, already attuned to these types of rules and regulations. It may be that there isn't an appetite. That's the first point. Secondly, I think it would be very difficult for states to wade in because these virtual worlds are off limits to that extent. And this is why I think it would be possible to regulate crypto assets, I would have thought, but that hasn't been done yet. It hasn't been done other than money laundering regulations here in the UK and across the EU. Because again, it's the freedom, it's the anonymity that is an advantage when you compare this with fiat currency and dollars and rupees and pounds and euros. So I think we have to appreciate this. This is a brave new world, and not everyone thinks the same way. Not everyone wants to see these types of rules and norms replicated in these virtual worlds. But the third point, I think, is that there is scope for this type of this type of regulation, or at least a light touch kind of regulation, where we can be sure that a metaverse operating somewhere is subject to the rules of the place where its main servers are. Possibly all those servers, as we know, are located all around the world. And the whole concept of a decentralized ledger is that there are all of these nodes, all of these virtual machines everywhere around the world, all recording these transactions or recording events that happen within the blockchain. So I think there is scope, but it's a big ask, I think, to say that there should be these rules, or that it's possible to implement these rules. We know the New York Convention has stood the test of time, hasn't been amended all these years, 70 years is it, with worldwide enforcement. To think that we'll be able to reach some similar stage with a metaverse, all these metaverses, which seem to be popping up and increasing as weeks go by, is, I don't want to be defeatist, but it seems quite optimistic. So I think we have to get used to the fact that there will be these individual metaverses, and it may well be for a time that we have to try to see how they fit in with our current methods of dispute resolution as more systems are found. I'm very sorry for taking up all that time, but those are my views.
I completely agree with Neeraj, and I think even if there are international rules or guidelines which are established, states will have to implement them, have their own domestic legislation which will implement them. And that might be an issue. Like the New York Convention example is really great because there's about 150 contracting parties. But then again, the ICSID Convention, which is the Investor State Arbitration Convention, that has not been signed by India. India is not a signatory. So it depends on the state's appetite as well as what people want. They'll just stop choosing for these guidelines. I mean, like we just discussed, when they choose ADR mechanisms, they can choose the applicable law. They can just choose the law of countries which do not have these kinds of principles adopted in their legislation. So it is a big ask, and we are yet to see what's going to happen, but it is certainly possible because a lot of governments have expressed concerns over especially cryptocurrency platforms in trading because it is not regulated. So similarly, if Metaverse gets out of control, that will be something states would want to regulate.
Indeed. So now my next question would be more like a turnaround. Blockchain as a technology was, as far as I can remember, first used in the financial world to test out global financial transactions with ease and security. But then once that technology has been built on, and now that we have the concept of metaverse, not just the concept, but we have metaverses already. So then when I talk about individual freedom, and for example, my freedom as to where do I want to resolve a dispute, my freedom as to how do I want to get it resolved, and my freedom as to maybe I want to get it resolved in metaverse itself. It pertains to an NFT, which again is not considered as an asset. As of now, it's not considered as an asset in India and many jurisdictions around the world. And I want to get it resolved in the metaverse itself. So would it not pit the individual freedom against the policies of the state? Because there is this void with regard to as to what actually would play out in that regard. Because on one end, we understand that metaverse is the future, and this blockchain technology has been there for so long, and the decentralized nature of it makes it democratic. But giving that power to the people in every aspect, as again it was iterated by both of you, that it can actually not sit very well with the government. What would happen in this regard?
Want to go first, Neeraj? Sorry, my voice is gone. But do you want to go first, Neeraj?
Sure. I'll pitch in with. I've got some views on that. Again, it's almost a philosophical question. It's difficult to answer because I mean we are privileged because we are at this time where these systems are all being developed and we have some input, or I say we, our generations. I'm a lot older than you now, so your generation in particular will have a lot of input into kind of where do we draw the line between the liberalization of the metaverse, or keeping it in that sense, free. People can go in as an escape from the real world, but then how do principles of property ownership map across? They don't really map across. You can go into a virtual world, buy some land, build something, and someone can come in and buy some land next to you, and you can fall into a dispute with your neighbor. How do you resolve that? How do people want to resolve that? If there is a buy-in to resolving that type of dispute in the metaverse, then maybe there isn't a room for the sovereign, for the state. Maybe by entering, you, as I said before, using a slightly different phrase, you're leaving those issues at the door as you go into the virtual world. You make the choice when you buy your tokens or you buy the right to go in. And that's another question about democratization, because how accessible is it? Buying these headsets, the technology has improved massively, but for virtual worlds or holograms or entering into these virtual worlds that aren't app-based or aren't web-based, there are barriers to that entry, but that's a separate point. Going back to this question, it really depends on appetite, depends on what people want. You probably better find a virtual world or an individual. What about when people have their own virtual worlds and how they mingle with others? It's in a sense mind-boggling. It's very theoretical at this stage, and that's why I say that the question is sort of philosophical. For me, I would draw a line. I can understand why states would want to have regulation, at least of some kind, to ensure that wrongs that are committed within the metaverse that have an impact on people in the real world, causing loss to people in their physical world, I can see how the state would want to be involved in that, and I can see there's a reason for that. But where this is an escape, and I think it's pointed out by my colleagues already, the metaverse really developed out of gaming and online entertainment as an escape. And it may be that there's a lot of hype about metaverses. It may be that that's where they remain, and businesses aren't going to. There are law offices opening offices, virtual offices in metaverses.
Right.
Is this a fad, or will we row back from this? Will people think actually we want the real world? We have Zoom and these other online tools, and that's good enough for most of these transactions. We'll keep the metaverses for leisure and entertainment. In which case, I think it's a lot easier to regulate. Again, just some views, but I appreciate there may be differences.
I agree with Neeraj, and I think there's a lot of so in the real world, just distinguishing the metaverse and the real world, there are repercussions to every actions. And if you use metaverse as an escape, and people are now investing millions of dollars there, even companies are investing millions of dollars in having their own establishment in the metaverse. So it is moving a lot towards having exactly a real life experience in the metaverse. And that is why such crimes or any issues that might arise, for instance, there have been intellectual property disputes where people have been creating Meta Birkins, which is the Hermes bag, which is supposed to be extremely expensive, and they've made a lot of profits on that, and Hermes has complained about the same. That there's been Louis Vuitton has had some similar issues. So there has to be a line which should be drawn, but this is something I'm saying because I do not yet have control over establishing guidelines, or that's something which will happen as we see the growth in the metaverse. And I agree with Neeraj's last point, which said that if people are just using it as entertainment, it's much easier to regulate, but that's not what's happening. It is increasingly, it seems to be like people want to have the real life experience. They're gonna commit crimes because it's just easier as an anonymous person. It's just very philosophical. It's very something that cannot be predicted at this stage, but of course, if you were to ask me, I think there are some lines which have to be drawn, especially when it comes to criminal offenses as compared to civil offenses. I think those are more important or serious and should be regulated somehow. I'm not sure how, but somehow.
Can I just come back on that? I agree with those points. I just want to pick up on one thing that Niyati mentioned. I think Mayank, you also mentioned this earlier, which is about privacy and concerns that people have. I think there is huge scope for unlawful activity with data scraping. You know, when people have these headsets on, their eyes and their expressions all being captured, recorded, possibly this data being scraped, sold on. All the issues that we are quite familiar with Web 2. And privacy and data protection, these are amplified in the metaverse, because the metaverse is not just, you know, going online, looking at a platform on a website and then coming off and switching my computer off. These are potentially virtual worlds 24/7 where people are in the real world. So you're not necessarily, you know, you're not in two places at the same time in that sense, because you have a switch off, but the virtual world carries on, and there's huge scope for fraudulent theft of identities. People, you know, you can have these deep fakes. I don't know if you've come across the images being altered, video being altered, so you can have a video of a celebrity and you can make them talk, because you can use quite easily, you can use software which can mimic and reproduce somebody else's features. You know, there is a huge I can understand why states will want to regulate that kind of that metaverse. You can't sort of regulate in pieces. I think you have to regulate to the extent that that type of activity must be capable of investigation and of there must have some repercussion. Otherwise, you know, we're going to have the same issues that we've had in the last few years, which have led to a slew of data protection regulation, quite complicated and quite invasive in many ways. But for consumer protection, it's difficult to see how you can avoid having that in the metaverse. Otherwise, the phrase I used before, it's the Wild West. So I think if we want a rules-based resolution process, a dispute resolution process, there need to be these types of rules.
Indeed.
I think we also have someone who has raised their hand. So pardon if I mispronounce your name, Mr. Ataturk Phyllis.
Yeah,
you please?
You pronounce well. Thank you all for the presentation. So I have a question. As of the essence of international investment arbitration, we see a country that is mostly developing and then a private company, and the land is owned by the developing country or the country which we consider. But in what comes to my mind is in the metaverse, the condition is very different, because as much as I know, the virtual land is owned by the private company. So there will be on the one hand, there will be the commercial arbitration will continue as well as before, but for the investment. So seeing that the state as an investor, rather than the form of a state in natural path of the investment arbitration, will it change and modify our understanding of international investment arbitration and international investment law? What do you think about that?
Do you want me to go first?
Yes, I don't practice so much investor state arbitration, so I'll be interested to hear your views and see if I've got anything to add.
Yeah, no, that's a very interesting question, because generally in investor state arbitration, an investor invests in a state and not in it's not an asset of the state that they have invested in. And I don't think that's probably going to be a commercial arbitration, unless it's a parastatal, so this would be a parastatal, right? As you're mentioning, so a state has invested in the metaverse, and that's parastatal. So it's wholly owned by the state. However, if it enters into a joint venture with a metaverse user, that's going to be a dispute under a treaty if that country and that user's country have a bilateral investment treaty. That's going to be a normal kind of a dispute. I've seen a lot of those kinds of disputes where a state-owned entity, mostly mining companies, enter into a joint venture agreement with private parties, and then ultimately they breach the contract, and the contract provides for investor-state arbitration under ICSID or UNCITRAL rules, and that's something I've seen. So I don't think the nature of investor-state arbitration would change in that sense. However, if they don't enter into a joint venture dispute, it's just a state entity which has a dispute. I think that's more of a, if they choose for arbitration, it's gonna be more of either an ad hoc arbitration or a commercial arbitration. I don't think that's gonna be an investor state dispute, because there is no investment in this case, right? Investment by the private party, that's what I mean.
Yes.
But that was a great question, thank you.
You're welcome.
Right. I think we have some other questions from our participants.
Hi. So I have a question. My question: who?
I think there's a Mr. Garrick. I think there's a connectivity issue from your end.
I'll type in the chat box. Is that okay?
Yes, yes. You can type it in the chat box. So in the meantime, I'll just like to have the speakers touch upon very briefly as to crypto does solve this issue of cross-border disputes being much more efficient. I'm sorry, not crypto. Metaverse does solve the issue of cross-border issues being much more accessible, because parties, again, as has been illuminated by the speakers themselves, do not have to travel across the world just for the sake of an arbitration. But then again, does it also not set back the process itself? Because for a process like arbitration, the arbitrator needs to take arbitrator needs to not be biased to any of the parties. The arbitrator also needs to be able to gauge the interests of both the parties. Is it actually possible if we go through the route of ODR?
I'm happy to take this, especially after conducting and participating in hearings during the pandemic. I think Neeraj will also have some thoughts on that. We had hearings on Zoom, and it was very difficult to gauge the arbitrator's interest. I think sometimes it gets monotonous, especially during opening and closing arguments, because they just go on, they're longer, one person is speaking. And that's why I think Metaverse is really great, because everybody gets to be there in this Metaverse and really create a very real life like experience. And I think that's going to be great. I wish that happened for our virtual hearings. But during the pandemic in March, I think we were going to have a hearing, which was, then we had it in October, but that was still virtual. And I think we still had those issues where people were not as comfortable with just having a virtual hearing. I mean, we used other platforms for display of documents, for having ease of exchange of documents, as well as presentations with witnesses and all of that. We had to arrange for all of that. But if we could do that in the Metaverse, I think hearings could be much more effective.
Yes, I concur with that. I mean, there are 2 points I'd like to make in addition, which is, firstly, I found virtual hearings can be even more exhausting than physical hearings where you've got a multi-day hearing or trial. And because of that, you're having to concentrate. You're looking at the screens all the time. I mean, you can be looking at screens in a physical arbitration because there are so many screens in the room often. But I do agree that there are advantages to hearings preceding the metaverse. And just to give an example, for example, where you have a construction dispute and you have arbitrators needing to see defects in a power plant, for example, the construction of a road, and having a virtual experience where everybody can be in the same place. And we've got to bear in mind here, this is highly developed, these systems. You have people's expressions, their hand gestures. It's quite realistic in that sense, but you can see how that would be highly beneficial to arbitrators walking around rather than having to go and travel thousands of miles to see the insides of a building. So I think that's an advantage. It's a possibility that is an improvement on the current systems that we use. But then again, on the flip side, we have, it is, I've heard that people participating in sort of mediation processes in the metaverse, you have to wear all this gear, you have to buy this gear, it's costly, it's just as tiring to be walking around with a headset or some of this technology is at the moment isn't cheap. So whilst it may work for high value cases and high value disputes, maybe less so for ordinary disputes between businesses, small businesses, or consumers and businesses. So there is going to be scope, I think. There's going to be scope for those types of disputes being resolved with that type of technology and more online-based forms, like I discussed earlier with ODR.
So I think we have that question which the participant earlier was trying to ask the speakers. And I guess that would be the last question that we take up for today. And the question deals with that: who do you think should formulate cross-border crypto law? Centralized entities such as intergovernmental organizations, or is an international agreement more suitable?
I mean, sorry, go for it.
No, you go ahead.
No, I was going to repeat something I said for the first question, which was, even if an international body creates some guidelines or formulates cross-border crypto law, it's going to be the states, because states are sovereign entities. They're going to have to adopt it into their state law. There has to be a legislation which will say crypto disputes procedure. I don't know what it's going to be called, but it has to be adopted. So whoever even does formulate these laws, it has to be implemented by states. Otherwise, there is no enforcement. That's the problem with international law, which I think all of us would. That's like the biggest issue. There's a big enforcement issue, because if states, even in international arbitration, if states just don't comply with the International Arbitration Award, it's very difficult enforcing an award against the state. But I'll let you continue. That was my initial thought.
Well, I fully agree with that. I think if the question is along the lines of, is it an international agreement that is necessary or national laws? I think the national laws come first. So I agree with Nyati on that. That just like with New York Convention, states previously enforced awards. There may be bilateral enforcement. Then there are common law rules, for example, in England about enforcement of awards and the principal basis for enforcing awards, arbitration awards in other jurisdictions. So it starts with national governments, and it may be that one or more governments take a role in developing regulation or law regulating crypto assets, and then that will be adopted more widely. I think that's the way it would go. I don't think there is. That's usually how international law is developed. Actually, it's very rare that you have all parties, going to in one room and deciding that they're going to implement international law in a particular way. Crypto assets is no different. I think there'll be a gradual step-by-step regulation and creation of law by national by states.
And I think with that, we've come to the end of our moderated general discussion. And it was indeed a privilege for me, being a law student, to be able to host industry leaders. And this discussion, I think, was an eye opener for everyone. Being able to interact with the panelists is, I think, was a very good opportunity for everyone to be able to understand what the best legal minds in the industry are thinking about the changes that are yet to occur. Before we move on to the closing of the session, I would just humbly request all the participants to please switch on their camera so that my colleague would just take a screenshot of everyone. If we can do that for once, please.
I also want to thank everybody in India who's spending their Friday evening with us. I know it's Friday evening, so thank you so much for being here.
Yes,
Thank
I
you.
echo those thanks as well. Very conscientious of you, but very, very good to have you all. Thank you.
Thank you. Thank you. Garrick, I think you can take this screenshot. Done with it? Okay. So I would like to invite our faculty coordinator, Dr. Zubair Ahmad Khan, to give the vote of thanks for the speakers.
Thank you, Mayank. Very good evening to all the respected dignitaries, faculty members, and the dear students. It's really wonderful to all you have here in the event also. And on behalf of Law School, on behalf of ADRSL, USLLS, it's an honor for me to give a vote of thanks altogether. And after a very long period of time, we are organizing this kind of event also. And one of our alumni is also participating. That is also bring us more delight to all of us. I'm really thankful to the respective dignitaries also. First, Elizabeth Chan, who discussed about introduction to Metaverse in particular also, and what are the enforcement issues with regard to arbitration in general. Niyati Oja, who informed us about the basic concepts of ADR disputes in the Metaverse, and that explores number of questions, and she very responded all the questions very sincere and very mature manner. That's something very kind of a delight has been brought to us. Now Nicholas has discussed about the smart contracts and what are the innovative areas which should be discussed also. Considering the issues of investment arbitration in the metaverse, it's something a new area, a new dimension which needs to be explored further altogether. I also like to give my sincere gratitude to Neeraj ji, because who have given our precious time to all of us. We'll discuss about the different aspects of ODR and allied technologies and how does it actually create an impact in the ADR mechanism engine also. And I'll also like to give my sincere thanks to my faculty colleague, Professor Queenie Pradhan, my dean, Professor Amarpal Singh, and my faculty colleague, Dr. Vandana Singh, who has been instrumental in organizing this event also. And last but not the least, I like to give my sincere thanks to all my student coordinators, Mank, Dipanshu, Garrick, and many others who have been part of this event altogether. And I'm sure we'll have another successful day event tomorrow. So hope to all of you to join together on time. Thank you so much.
Thanks a lot, sir. And we look forward to be able to host you all on the second day of the conference, which is tomorrow. And timing for the same is 5:30 p.m. IST, Indian State Time.